Happy to introduce the speakers of the last seminar of this year, because I know the students are soon in the exam period and writing papers, so we're really happy that we have a good turnout for Abortion Law, Illiberalism and Feminist Futures by Joanna Erdman and Paola Bergalo. So I'll first introduce Joanna, who is a professor, the inaugural McBain Chair in Health and Policy at the School of Law at Dalhousie University. Her research focuses on sexual and reproductive health and human rights in a transnational context. She has acted as an intervener before various constitutional courts and international bodies, and as an expert advisor with the World Health Organization. Joanna holds a JD from the University of Toronto and an LLM from Harvard Law School. She completed the fellowship at Yale Law School, and many people here obviously know Joanna as the former director of our reproductive rights program. We're also very happy to introduce Paola Bergalo, who is an associate professor at the School of Law at the Universidad Torquato di Tella in Buenos Aires, who I had the pleasure of meeting when I was teaching a course in the very engaged faculty of law there. So Paola is a law professor, researcher at the Law and Government Department at Universidad Torquato di Tella in Buenos Aires. Her academic and advocacy work connects law, public policy, and social change in the study of gender and health matters. She's a global fellow at the Center for Law and Social Transformation of the University of Bergen. Since 2020, she has directed several research projects on human rights and development matters at Fundar. She has taught at the universities across the Americas and Spain, has headed law and policy projects, among others, for UNFPA, the Food and Agricultural Organization, the Nordic Trust Fund, and the World Bank. She holds a BA with honors from the Universidad de Buenos Aires, an LM from Columbia, and a JSM and JSD from Stanford Law School. So with this, we know that we will have a good presentation. I'll give you the floor. We open it afterwards for questions and discussion. Thank you.
Great. Thank you so much, Trudeau, and thank you for the invitation to come. It's wonderful to be back at U of T. It's sort of like a welcome home. Things are different. Not really, it's the same. You just have a feeling walking through the halls of a memory of being a law student and yeah, teaching here for many years. And it's really wonderful to see Rebecca too. It's a real welcome home. So thank you. And it's a real gift to present with Paola too. I think you'll see, and we're going to try to put in some of our own personal lives into the work. I think it's very much a work of coming of age in the abortion world. And so that's how we'll present it. I was just thinking it's maybe like 6 months out until Paola's like a hologram right here. I think that's where we're going to head soon. But it's nice to see you're large and present on the screen. Did you want to say a word of welcome or introduction, Paola?
Mm-hmm.
We can't hear you.
You have to unmute.
Sorry, I just wanted to say to thank you, Trudeau, for the invitation. It's a pleasure to be here and there. Now I'm even watching me there. Also, thank you, Joanna, for the opportunity to write and to think about this process and this coming of age with you in the last several months. And gracias totales, as we would say, as rock band say in Argentina, to Rebecca and Bernard for hosting me almost 20 years ago when I visited Toronto. I wanted to meet Rebecca and to share with her the idea of building up a network of feminist law professors. And I met her and Toronto for the first time. And since then, I have received her support and Bernard's support also in many different ways. So it's a pleasure to be here. I can't see you, but I know you are there. And I'm very thankful for this opportunity to share with you what we have been thinking and researching with Joanna. Thank you.
Great. All right. So I thought I'll start and take a few minutes to set the scene for this research. So this is a work that we are preparing for one of the annual reviews. So the annual review of law and social science. And they asked us to write on abortion, law and politics in comparative perspective. And I think when they asked, they had an idea of an article in mind, because there's a kind of convention to writing these types of comparative works in abortion law. And the usual move is to compare the abortion law of many different countries, usually organized regionally, and they do so on a scale of liberalization. Yeah, so basically how liberally the law allows for abortion, and they sort of compare countries on that measure. So for example, does the law prohibit abortion outright, or does it do it with exception? If it does it with exception, how many exceptions, for how long, and what conditions? And this usually looks like exceptions for cases of risk to life or health, or in cases where pregnancy results from sexual crime, or where there's a fetal diagnosis. And then rather in a fascinating way, you'll find time limits of just so much variation. 12 weeks, 14 weeks, 24 weeks, or no time limits at all. And then all this variation about who can provide an abortion where and with what authorizations. And it's almost like this is the abortion law trade, we like to say. Yeah, you work in these features of abortion law and you create these abortion law taxonomies on the basis of these regimes. And so there's a convention to it. But there's also a really interesting history to comparative abortion law, and this tends to get lost in some of these comparative articles. And it gets lost because it's harder to write. It's harder to write the story of the association with abortion laws and political regimes. Yeah, they don't correlate so perfectly. So it's absolutely true that abortion law has always figured in nation building and state formation. Abortion law is absolutely a feature of apartheid regimes. It's been a tool of military rule. It is often a mark of democratic transitions. It's been reformed in both, I would say, favor and contempt for religious authority. It works both ways. And it is also a very key part of European colonization. And you see it's left a legacy of criminal laws, especially in Africa and Latin America. And that history in many places is still the present day contemporary law. So in the paper that I shared with the students, you could see I work with abortion rights in that political context, and really the way in which different countries have asserted abortion rights in different ways in a post-colonial context as well. But here's the thing, you have that whole political mix, and yet over the last 50 years, there's been this general trend, we say, toward abortion law liberalization. And you can fight about what was the key determinant of that liberalization of abortion law. There was this growth of a dedicated field of public health research all around abortion law. There was a transnational feminist global movement on abortion law. There were global human rights norms that came about, but all of it ended up converging on abortion law in a certain way, such that you had abortion liberalization as the general trend of the last 50 years. So in the 1970s, you had governments in US states, you had governments across Europe who began to pass more and more liberal laws. You have courts that declared these laws constitutional. Later, courts would not only declare the laws that parliaments passed as constitutional, they would then say those are constitutional mandates. And so this, of course, is the Roe versus Wade decision. And we had our own decision during this time. This is the 1988 Morgenthaler case as well. And then in the 1990s, abortion rights started, I would say, tentatively to move into international law as well. So year by year, the references to abortion in international human rights law continued to grow. The strength of the engagement continued to grow. Rebecca and I have written about abortion rights in international law, first supporting depenalization, then liberalization, and now complete decriminalization. And those international abortion rights then were folded back into national politics. They became part of the national scene. And this was especially true where you had a number of these abortion rights cases around the world. And so the kind of forum of engagement switched. It was much more about litigation and less about legislation. And that meant your political actors also changed. It was much less, I think, about legislators and much more about lawyers and judges. I actually thought this was always fascinating. In the US, you actually have an abortion law bar, yeah? Lawyers who practice nothing but abortion law, which is quite extraordinary to think about. But I think all of those features then of abortion law that we had seen or I had discussed of time limits, gestational grounds, who could do what, where, and how, when they were made by legislators, they were political compromises, and they were openly talked about in that way. But in this new era, those compromises became part of constitutional law and constitutional doctrine. And so they started to be talked about in these kinds of calculuses of balances and proportionality. And in international human rights law, we started talking about margins of appreciation. And courts really, again, traded in these features of abortion law. Yeah, they borrowed, they modeled off of one another. Abortion rights really became a focus of comparative constitutional law. And so I wanted to pause here to just say that Professor Cook and Professor Dickens, who are online with us, you were immensely important to this period of abortion law development. And if you travel the world, you will witness their celebration, absolutely, as a really big part of abortion law liberalization the world over. And so you're very lucky, I think, to have them here at the law school. They are historic figures. They are global figures. And I was very lucky too, and Paola too, because we very much grew up as abortion law scholars, learning with them and being supported by them in our work. And so we learned absolutely about this world of abortion liberalization. We practiced it, and we did so with many, many friends around the world. It's this almost practicing community, and we did it in this absolute belief of the democratic commitment of that liberal abortion law. And so that's what we were all doing for a very long time, decades of work. But the world changes. Yeah, the world changes. It is always adapting. And today, I think you continue to always have a part of that era, yeah, of abortion law liberalization. And you can still see there are many feminist movements, and they are bringing their claims before constitutional courts, and they are finding big and celebrated successes of judgments. And so probably most recently, we've had big judgments coming out of the Constitutional Court of Colombia, big judgments out of Mexico. This is part of what we call the green wave of liberalization in Latin America. But something's changed. Something's changed in the world order. And the change has been that you're having that continued historical legacy go forward, and you're also having really and striking attacks on abortion rights at the same time. And you're having these attacks in a contemporary moment of authoritarian governments and their very strong anti-gender ideologies. But their attacks on abortion rights today look different than they did in the past. And that's something we took notice of. And the reason the attacks look different is because they're coming by way of courts and constitutional rights. And this is something different. They're also coming by way of ministries of health who are regulating abortion as healthcare. This is something different. That used to be a slogan of liberal politics, yeah? Abortion is healthcare. And now you have authoritarian governments saying, absolutely, abortion is healthcare, and we are going to regulate it absolutely as healthcare. And so there was this flip, yeah, in the argumentative structures. They look familiar and they feel familiar. They're speaking absolutely in the language and the grammar of human rights, but they're doing so to defeat abortion rights. And more importantly, they're borrowing from liberal abortion law to do it. And so many other scholars in other fields of law have been noticing the same turn or the same contemporary happenings. And we've significantly relied on their work to better understand just what is this relationship between illiberal politics and liberal abortion law. There's something there. This was our work. We know this stuff well. And so we're watching the happenings with a particular interest and trying to understand the relationship between the politics and the law of this field. And then we're also asking the question of what comes next. Yeah, how are feminist movements going to respond to this moment? And so the argument is, well, you can do two things. If you have a capture of liberal abortion law, feminist movements could fight for a different kind of law. They could fight for democratic law, or they could abandon the legal project altogether. And the paper really looks at the fact that feminists are following both of those futures. Again, the field has fractured in this way. So that's the story we're going to tell today. That was the preview. We're going to work this idea of abortion law, illiberalism, and feminist futures. I'm going to start with a few case studies around illiberal abortion law or abortion law's illiberalism. And I'm going to look at the ways in which courts and governments have mimicked or mocked or misused, if you like, liberal abortion law to illiberal ends. And then Paula's going to share one of the feminist futures that we're tracking. So going to look at the potential of remaking abortion law as democratic abortion law with a particular focus on Argentina. And of course, it's a particular focus because of the uncertain future that feminist future now faces given elections last week. So that's the plan for the day. And Paula, do you have anything to add to the intro before we get started in the material?
No, go ahead, Joanna.
All right. So in this section of the article of abortion law illiberalism, again, we're watching conservative legal arguments or anti-abortion rhetoric that looks too familiar. Yeah, that's the idea of it. These are features we usually associate with liberal abortion law, and they're being flipped to other political ends. And so in this part of the paper, I look at three specific features of liberal abortion law. This is the abortion compromise, abstraction, and procedure as three core features. So let me start with abortion compromise. So this was, I think, accepted as the absolute feature of liberal abortion law, which was the idea that you could have plural politics in liberal abortion law. You could accept that there were rights on either side, and the goal of the law was to try to strike a compromise between them. And it tended to use this constitutional language of proportionality or balance or margin. I can't tell you how many times in my career people would accuse me or critique that I hadn't done the other side. As though this was the absolute need you always have to do in abortion law. You have to do two sides, always two sides. That was the structure and the setup. Of course, what happens in this compromise is that liberal abortion law always maintains the criminal prohibition. It keeps inside of the law this repressive element, even if it keeps carving out ever more liberal exceptions to it. But the idea is you would strike a reasonable balance. Yeah, you'd always strike a reasonable balance between rights and repression. But of course, compromises can be dangerous because the compromise can shift over time. When you give more, people will take ever more until eventually, potentially, they take everything. And so indeed, this is what happened in both Poland and in the US. People might be very familiar with the US judgment in 2022. The US Supreme Court overturned Roe v. Wade and declared that indeed the US Constitution does not protect abortion rights. There is no abortion right in the US Constitution. But the truth is that decades of litigation on the Roe right had so compromised that right that very few people considered it a right anymore at all. I mean, from the 1980s, really, the court had been upholding the right, but allowing ever more restrictions on the right and allowing it precisely as being just a part of that reasonable compromise of the law. And eventually, indeed, the lawyers got really smart And they told the legislatures, you should restrict abortion rights, but you should name it as in the protection of health and women's rights. Put it on the other side of the scale. And so eventually, indeed, they started to claim their restrictions as protections, and the scale started moving in the other direction. And so if you watched abortion law in the US over this time, I mean, its machinations were almost obscene in thinking about the scales and the balance and substantial obstacles and undue burdens. Actually, the case that told you what happened was the case that came before Dobbs in the US, and it was the US Supreme Court Justice, and he wrote, when he was trying to work out this doctrine of compromise, and he said, come on, it's like asking whether a line is longer than a particular rock is heavy. Like the doctrine was so absurd at this point, and the larger idea was therefore that eventually this compromise of the abortion law just cannibalized. Yeah, there was nothing there anymore, so it was pretty easy then when the US Supreme Court had the chance, because right-wing political governments had stacked the courts precisely to do this, then declared there's no right here at all. And that's what happened in the Dobbs decision. In 2020, the Polish Constitutional Tribunal did almost the same move. Yeah, and the same kind of judgment that provoked a national crisis. Because there in the law, you had 3 exceptions in the compromise. One of the exceptions was legal abortion in cases of a diagnosis of fetal impairment. It was an openly political judgment. This was another stacked court. And absolutely the judgment that the tribunal gave was a gift to the Law and Justice Party at the time. But the tribunal was very specific in its reasoning and said, no problem here. This is just usual legal abortion doctrine work. And it pointed to a 1997 precedent of the same tribunal when at that time you had a different government who wanted to add a new exception to the law for social hardship. And there too, the court simply balanced out the rights and declared in this instance that the right shifted the other way and another abortion right just fell off the balance. And so in other words, they're constantly using this idea of compromise, which comes from liberal abortion law, to drop more and more abortion rights off the scale. The second feature of liberal abortion rights at play is a feature of abstraction. I think when you read these judgments, they can have a kind of disorienting element to them because they're done in such an abstract calculus, if you like. But that partly comes from the abstractions of liberal abortion law itself. And I think particularly because abortion law started to be made by courts, and courts particularly who were doing abstract reviews. And so they ended up articulating abortion rights as these fundamental rights to life, liberty, equality, privacy, security. And again, there was a value to this abstraction. The value was that abortion rights could travel across legal systems. This is really what allowed abortion rights to move from international human rights law into national constitutional systems, the level of their abstraction. But if you think about it, this also has a kind of authoritarian edge to it, because this idea that abortion rights have no textual reference, they have no political orientation, they come from some transcendental source that is beyond law and beyond politics. Well, that starts to have a whiff of natural law, if you like. And at some point, if you have the right political mix, then abortion rights can come to mean anything or nothing at all. And again, this is exactly what happened in the US and in Poland. When, again, the US Supreme Court overturned Roe v. Wade, they absolutely followed this script of a fundamental abortion right. Only this time they said, if it's so fundamental, then we should be able to find it in the constitutional text or in the nation's history and tradition. And they said, we can't. We simply can't in the US context, and so we are going to return it to politics, where indeed women, you do have abortion rights in the political context. You have political rights to fight for your abortion rights. And so there you have it again, this kind of flipping constantly about what is the nature of the abortion right. In this case, it's not a right to life or to liberty or to health or to privacy. Instead, it's a political right to fight in the political realm for your abortion rights. So again, there's this strange, I think, consistency with liberal abortion law, insofar as these courts are always very particular to say there's nothing restrictive about our judgments. Our judgments, in fact, are rights protecting, even while, of course, they absolutely undermine abortion rights. And at the international level, the Trump administration was doing exactly the same thing. What the Dobbs Court decision did in terms of differentiating fundamental rights from political rights, the Trump administration did at the UN level when they distinguished between those so-called ad hoc women's rights that were made by political agencies and the true rights that were laid out, for example, in very early civil and political rights documents. And in fact, later they would put forward a political position, the US, and it was very much signed by a number of other illiberal governments who said, look, we just can't see any international human right law to abortion at all. Where is it written in any of the texts of your treaties? The idea here was that they weren't wrong. They weren't wrong. There had always been this conservatism in international human rights law, and that's what they were exploiting. There was always a conservatism in never speaking of abortion rights. They always spoke through other rights. And there was a conservatism, especially in European human rights law, where they always kept alive the idea that the right to life was there. It just was balanced out in liberal abortion law. And again, this was a feature that the tribunal in Poland took advantage of. Because again, when they struck down that abortion right, they didn't do it in any restrictive terms. Instead, how they framed that 2020 judgment was that, indeed, it was rights protecting. They were just protecting a more fundamental right. They were protecting the right to life of the unborn. Indeed, they weren't even protecting the right to life of the unborn. They flipped it in a more liberal script to say, we're actually protecting equality rights here. This is a protection against eugenic practices on the basis of disability. And so what's really shared across the courts is this almost performance of rights protection in the denial of abortion rights. And they're not using argumentation that is based in a morality, an anti-rights argument. They're using absolutely the liberal grammar. They're using the liberal discourse of human rights. And so the last piece that I want to look at here is the idea that courts really matter to doing this work. And I think there's a reason why authoritarian governments have captured them. And it's because courts do work in this kind of abstract realm and then can therefore rule authoritatively from the abstractions of law. And this, I think, is something dangerous that happened in the liberal era when feminist movements really raised the capital of courts in promoting abortion rights. And it was specifically dangerous in the Latin American region, where, in fact, courts have not been liberal actors. In fact, they've largely served elite interests. And the way they've served those elite interests have been primarily in their very conservative relationships with governing power. And liberal abortion law didn't at all disrupt that relationship of courts to governing power. In this piece, we argue that, in fact, liberal abortion rights strengthened it. And so this is the final and last element of procedure. So how did it do it? Well, if you looked at the liberal paradigm, abortion rights always assumed that there would be more law rather than less. And they did it because there was this idea that once you liberalized or decriminalized abortion, you needed regulation to make that right effective. Yeah, you needed to implement the right to legal abortion. And so abortion rights in international and in constitutional law became the right to have policy guidance, the right to have procedural protections. And in that, in fact, liberal abortion law really worked with rather than against governing power. If you like, it basically created a conduit for authoritarian power through the regulation of abortion rights. And in the piece, we tracked two case studies of this, and they're really fascinating case studies, one in Ecuador and one in Brazil. In Ecuador, there was this really celebrated 2021 constitutional judgment from the Constitutional Court. You had a legal exception to the prohibition on abortion there, and it was an exception for cases of sexual violence, but it was limited to women with mental disability. And the court liberalized this ground. They said, no, this ground should be available to all women. And so the judgment was absolutely based in rights-based reasoning. But the judgment also focused on governing power significantly. Where the judgments here, they set judicial limits on the punitive power, but there was also a very clear judicial remit to the National Assembly to regulate this new abortion right. And the National Assembly absolutely did. It protected these rights so much that nobody can actually access them anymore. In the throes of political debate about how to protect these constitutional rights, the Assembly enacted a new abortion law that is more arbitrary than the law that the Constitutional Court struck down. And then fascinatingly, when this law reached the president of Ecuador, a president who was staunchly conservative, anti-abortion, but who promised to respect the decision of the Constitutional Court, he did so by introducing 61 new amendments to the law and claimed that now this law was necessary in order to respect the Constitution and the judgment of the court. And so this is probably one of the most restrictive abortion laws that we have ever seen. But what's really important about it is it now claims a constitutional mandate. It now claims to be in the interest of protecting abortion rights. A last note, and then I'll turn it over to Paola for the remainder of the time, is this really fascinating case of Brazil. In Brazil, during Bolsonaro's regime, again, a far-right populist government, we saw this really interesting relationship between illiberal, in this case, executive power and liberal abortion law, and it particularly came through Ministry of Health regulations. Probably the most controversial regulation was an ordinance in which they said we are simply regulating the right to abortion in cases of sexual violence. But the ministry introduced all kinds of procedural protections here for victims of violence, including, for example, mandatory reporting of these cases to the police. But again, none of the language of the government on this was about restricting abortion rights. It was all about protecting the rights of victims of violence, of which the abortion right was a component. And again, the idea is you can see it as one specific ordinance, but it's untrue. You watch it all the way through the ministry's actions on abortion. They also blocked, in this case, remote provision of abortion services during the COVID pandemic. And again, they claim to do it in the interest of the right to health, to protect against unsafe abortion. Even criminal courts in Brazil now make a claim that indeed the criminalization of abortion is a public health intervention. And there are so many cases that we have tracked in which people are being charged not with a morality crime of abortion, they're actually being charged with a public health crime where they possess abortion pills or distribute them on a public health crime of unsafe abortion. And this carries penalties that are as high as any drug trafficking or drug enforcement charge. So again, it's kind of a fascinating set of cases to look at. And I think the intention here is to say, look, they're not camouflaging their political purpose behind liberal abortion law. They are absolutely wearing their anti-abortion politics on their sleeve. And so instead, what are they doing with these practices? I think the idea is to strip power from liberal abortion law. That's what they're doing. They're stripping power from liberal abortion law, especially as a political resource for feminist movements. And so then the question becomes, what do feminist movements do? And that's where Paola comes in response.
Thank you, Joanna. So I'm going to share our ideas on democratic of what we propose to term democratic abortion law. So this is a different take on the story, and we could go back to Roe v. Wade and think at the same time what was happening in Europe in congresses and legislatures, where in Germany, France, Italy, and then Spain, we were having democratic conversations on abortion regulation. But I want to take you to the global south. So we need to move a decade ahead And I proposed to start in 1983, where the return to Argentine democracy started. And there we can start a narrative from the Global South, where we see the encounter of the beginning of the second wave of democratization and the role of second wave feminism, if you want to see, in the South. And their encounter in this project of democratizing what had been over the 20th century, authoritarian societies, violent communities and institutions that have, as in the case of Argentina, gone through several democratic breakdowns, coup d'etats, and a majority of the 20th century that was lived throughout authoritarian governments and different intermissions of very weak democratic elected rulers. So we are in the start of the second wave of democratization, and we see feminists also starting to fight for the politics of equality and inclusion and integration, and what we see as very strong modern ideas that in a way fit with the liberal tradition that Joanna was bringing, but at the same time, they are changing these ideas and I'm bringing, I would say, thicker descriptions of equality, thicker visions of the rule of law, democracy, and constitutionalism. So what we want to say in this section of the paper is that these current trends in what we call democratic abortion law and one of the futures of feminist abortion law has to be tracked back to this start of the confluence of new visions on the law, human rights, and democratization and democracy. And this is a very important point we want to make. The features of this era that we are seeing now in practice and becoming materialized in the reality of our democratic transitions and the stage of our democratic transitions has to be looked as a long process in which we have all been working with this regulatory ideal that in a way is much thicker than the liberal tradition that is instantiated in the liberal abortion law that Joanna has described so far. So in this tradition, key features of the ideas or the vision that is behind feminist conversations and also feminist mobilization from the social, the political, and the legal point of view, we have a thicker idea of the rule of law in terms of the demands, which are also tied to a vision or to a more dense vision of constitutional law that in the case of many of the Latin American countries where we see this democratic abortion law arising or evolving, have been called something that has been identified in other features and discussions of constitutional law as social rights constitutionalism, a constitutionalism that has a strong view on rights, but on social rights particularly. And this is part of the ideal that is connecting the rule of law, rights, and social rights in particular, and a vision of democracy that is also very thick in terms of inclusion, in terms of participation and deliberation. And we use 2 case studies. We could use actually 3, and we are thinking about Argentina, Chile, and Ireland to show this emerging view on democratic abortion law. And in that sense, we move more to an empirical observation or a socio-legal observation in which instead of going deeper in the features of the vision, we want to show how feminists in their social, legal, and political mobilization and in the coordination of the social, the legal, and the political that we see in these huge nationwide debates have organized and have performed and put forward this ideal of democratic abortion law. So for that, instead of looking at in a deeper perspective to the features, as Joanna has said, we suggest to look at the dimensions of the action, of the instantiation of this feminist future in the concrete settings of the liberalization of abortion law in Argentina, Ireland, and in the failed but very important nationwide debates that have taken place in Chile in the context of the Constitutional Convention, the plebiscites, etc., and even the continuing conversation that is going on women's rights, feminist visions of the Constitution, etc. today. So if we look at the Argentine case, I just want to share with you very, very few instances of this idea in the case about Argentina. In terms of the dimensions, we need to look and where we see some differences from the experiences that Joanna has described so far, we can look at the actors. And when we look at the actors, we see a diversity of actors that have been involved in the last 40 years in different instances of the fight for this vision of the rule of law, constitutional and social rights and democracy. And we can start in the early democratic transition and see women in the transitional justice arena of Argentina. There we see the Madres, the Plaza de Mayo, and also the women who were leaders of the Truth Commission that was set up by President Alfonsín very early in his access to the presidency in 1983. So there we see the start of the human rights movement, led by women claiming for their sons and daughters who have been kidnapped and disappeared, and also women leading the truth, the search for the truth about what had happened, and also women leading the registering of the records and the production of the evidence that was later going to be used in the famous trial that you probably heard about if you've seen the 1985 movie. So in that very early stage of the human rights development and the transitional development, women were there bringing rights and their claims as mothers and also as truth seekers and as leaders in terms of the institutional opportunity that was the Truth Commission. We can move forward 2 years ahead, and in 1986, we see the first organization of the National Encounter of Women, which is a very important key moment in terms of social mobilization. It's the start of an annual meeting that has been going on for more than 35 years now, starting in 1986, in which women have gathered every single year in different cities of Argentina to discuss the feminist agenda, equality, and many other claims that they brought to the democratic system and to the democratic arena through the last 40 years. So we see the start of the human rights movement and women's presence there, the start of a big national organization of women in terms of the national encounters. We also can move a little bit ahead to 1991, where you see Argentine politicians getting to pass the first quota law in the world, providing for a 30% of seats in parliament separated for women, which is also the instantiation of equality in the political project, in the institutional formal settings of representative democracy. And this is a very important moment that also has a complementary key moment in 1994, where we celebrated the first constitutional convention in the last democratic period, in which women sat for the first time also in the world, thanks to the quota law, as 30% of the constitution drafters in that convention. So there, and it is not a hazardous thing, women managed to set up a clause in the Argentine constitution that provides about political equality and that guarantee the constitutionality of the quota law that had been challenged in courts in Argentina. So we also see another democratic debate on the constitutionalization of the affirmative action for politics that takes place in the Constitutional Convention in 1994. And there we also see another key moment in terms of the law and constitutionalism and equality, which is the introduction of CEDAW with the other human rights treaties that are introduced in the Argentine constitution with constitutional status. So we see first the women's participation in the birth of the human rights movement of Argentina, which is one of the strongest human rights movements in Latin America. We also see women in the social mobilization. You could also trace the Ni Una Más escalation and massive taking over of streets in Argentina, many other places of the world, to the National Encounter of Women, and there are different campaigns for different legal and political and social reforms. And we can see this instantiation of political equality in the quota law and the Constitutional Convention provision about sex equality in politics, and CEDAW as a part of Argentine constitutional law in these first 10 years of the democratic transition. If we look at the second 10 years, we also see the liberal abortion paradigm coming to Argentina and working in the drafting of health guidelines, but with a broader liberal approach to health rights. also the litigation to react to conservative litigation that was taken to Argentine subnational and federal courts. And so we also see the birth of the legal mobilization of women who go to the courts and who inspired both in the human rights movements and their successes internationally, bring international human rights arguments to the local litigation and to the administrative regulations that take place in the health and administrative settings. And we see this other turn in the legal mobilization that is connecting this broader view of law, human rights, social rights, and also this view that is going to take with the years these conversations to Congress and to the streets, and so to the social and political homes of the mobilization that you look for with this idea of democracy, inclusion, and participation, and also the liberation that I mentioned to you. So a second dimension of all this process is the instantiation of this ideational view of the liberation and inclusion. And for that, we use the last stage of Argentine mobilization and democratic abortion law, which can be traced to the 3 years that go from 2018 to 2020. You probably saw and heard about the Green Wave and how women took over the streets of Buenos Aires and all the main capitals of Argentina to fight for the deliberation in Congress of a legalization bill. And so there we hosted a nationwide debate. You probably saw it. It was divided in two moments. First, we have the deliberations in the committees in the House that took us 2 months, twice a week, 8 hours each day, in which we heard 350 people, experts, advocates, national and international participants, debating and offering information, data, opinions, experiences on their relationship to abortion, which were 350 in favor and 350 against the liberalization proposal. Then we moved to the floor of the House, and the bill was passed by a small majority of 5 votes. And then we moved to the Senate, where we also organized another instantiation of the debate for 45 days, also twice a week, 10 hours, journeys of 10 hours, in which 150 people gave their opinions, experiences, and views on the liberalization proposal. And Senate took the discussion to the floor, and the bill was defeated. But this was not the end of the nationwide conversation. The following year, during the electoral process in which we selected our current president, we put forward a conversation in the context of the electoral process. The liberalization proposal was part of the campaign, of the national presidential debate, and of different conversations that took place among the candidates in different instances of that electoral process. And the president that was elected had proposed to send a bill to the Congress, and he complied with the promise in 2020 during the pandemic. And in the last part of that year, we had another institutional deliberation, now with the new members of the House and the Congress that had been reviewed in part the prior year. And we once again heard experts and advocates and women and men who opposed and defended the bill. And finally, in the course of a month, in late 2020, the bill was approved, promulgated, and started to be implemented by the Federal Ministry of Health and the 24 ministries of health of the provinces of Argentine federalism, in a process that is, of course, contentious, that has involved many different instances of new dialogue and many experiences as the one that Joanna has shared with you. But then you see the second dimension of this idea of this very thick and dense idea of the requirements of democracy that include participation, deliberation, and also a wide vision of inclusion, which can be empirically revised by the type of actors that participated in the debates for and against the conversation that we hosted at the national level. And it was a conversation that took place at home, but also in our organizations, in civic spaces, in the streets, but also in the main setting of democratic and representative democracy, the executive, the Congress, and the different spaces where we have been hosting our democratic conversations. So So this is the second dimension of this case study, in which we see this dense view of democracy, this very charged and thick vision of how democratic institutions and social life in a democracy could work to face intractable issues such as abortion. The first dimension that we wanted to highlight is the potential different effect that having abortion laws being produced in this democratic abortion era could have in terms of the stability and the reversal potential that the reactions to the liberalization could bring. So this is still an open question. And of course, there are lots of things to observe in terms of how much the enforcement of these laws that are the result of this deliberative process, of these thick descriptions in terms of also the social rights dimensions of these regulations, can have a different enforcement process. I don't know if less contentions, but difference because of the stability of having these visions about the rule of law, human rights, social rights, and especially the democratic view that legitimates the results of this process. So it's still a question, what are the effects in terms of enforcement and also in terms of stability? As you probably know, we have gone through a very contentious and different electoral process, and we have elected President Milei, who started his participation in the democratic arena with a very clear position against reproductive rights, abortion rights, and some of the very basic human rights in general, but who shifted very fast his visions from these issues to other issues related to the problems in the economic performance of the country, the inefficiency of our state, which has been a state with many big failures and important incapacities in terms of delivering human rights and other basic goods. So we don't know what this means for our democracy and for women's rights in particular. There is a big question in terms of what lies ahead. This is a candidate that has shifted a lot, both his ways, his tones, and his ideas in a very short period of time. So it's really a question whether this is a far-right reaction or something very extraordinary and typical of the moods of Argentine history. So we'll see. But what we think is that what we have seen so far is a process that has to be traced to the confluence of the second wave feminism and the wave of democratization in the South. And we believe that there are things to trace and to learn from the recent conversations that we have had in Argentina, Chile, and of course, Ireland, that could support the idea that there is a different way of doing abortion law if we take into account this context and these particular histories, which might connect to the early democratic process of the European countries of the mid-70s, but which has something different to offer too. And this is what we wanted to offer you as one of the potential feminist futures and the questions that lie ahead and the teachings we have in terms of comparing all these processes. So I will leave it here. We have a third feminist future, which is without law. But I think that this is more than enough for interesting conversation and receiving your reactions and critiques, because this is still at a very early age of development. Thank you.
Okay, so we open it up for questions and comments. So as usual, I will start with the students. We're going to take quite a lot of students' questions. And if anybody else wants to ask a question, put up your hand and I'll write you down in the order. So to the students, if you change your question in line with the discussions, you can ask something else. And so I'll simply start with Sarah.
Sure, I do have a different question. You were mentioning that a lot
If you speak up, because Paula has to hear it as well.
Sure, sorry. You're mentioning that regulations have been placed on abortion rights with the guise of healthcare. Have any of these regulations actually had any beneficial impact, or is it totally going against what it's aiming to do?
Yeah, it's interesting. I mean, the activists will tell you it's almost impossible to get through these procedures. You know, once you put a reporting requirement on a rape indication, people won't use the legal channel for access. And then the more important thing is, it's really hard to get government to start collecting data once they implement these, which again, questions how genuine they are. as health protective rationales. And the work that we did around the criminal courts that were looking at these public health crimes of distribution of the drugs. I mean, it's really fascinating because, of course, the public health evidence tells you this is one of the safest health interventions on abortion in decades. And yet the court uses the rhetoric, but not the evidence. Yeah, so there's a real selectivity in the ways in which they work with, again, suggests it's not a deeply held position, but again, the governments are not pretending that it is. They're almost doing it in a kind of provocative way, by calling it this, and meanwhile, with the other hand, absolutely maintaining a mockery of human rights while they name their policies in light of it. Yeah.
Rin?
Yeah, thank you. Thank you both for your presentation. And I think my question sort of follows on to that. There was a point, I think, in one of the papers when they said that there was sort of a shift to a legal frame, but it was really just sort of wrapping the religious dogma in legal terms. And I was really taken, and it sort of leads to what you were just saying, I was really taken by the comparison between an anencephalic fetus and saying, well, we're protecting disability rights, which are just, so medically and scientifically not the same consideration. And so from a sort of democratic or rule of law perspective, I was wondering if there are going to be any challenges or pushbacks against these sort of false comparisons.
Yeah, I mean, in that case, and also in Brazil, it was really interesting, that discourse that was picked up. And so the abortion activists, what they did was something that Paola kind of mentioned in the design of a much more democratic engagement in abortion law. And so very much breaking out of silos of activist groups and really working together with disability rights activists. And the idea there was to challenge some of the abstractions of the claims, so getting out of the idea of this being a set of labels or categories of law and becoming people, like people who were there to represent themselves and their families. And that was how abortion activists tried to change it. So it's interesting that it really went much more into a democratic abortion law, of which when you start to do that, you realize this grounds-based modeling is truly antithetical to a humanistic approach, to abortion law. So it's, I think, a great question, that shows the orientation of the different legal forms.
Paola, would you like to add something?
Yeah, just to add that both locally and regionally, before 2018, we fostered several conversations among feminists working on abortion law reform and representatives of the people with disability movements. We started very early, actually, in the process to disseminate the approval of the Convention on the Rights of People with Disability. We started those conversations. And then over the year, we moved forward to set those conversations on abortion law, particularly. So there has been a connection among feminists and the movement on the rights of people with disabilities very early upon the work done around the approval of the International Convention. But in 2017, we even hosted a meeting in Bogota with representatives of the two movements to have a deliberation on whether we should write a document for the other indications, for the health indication. Rebecca and Joanna will remember that we work regionally in a dialogue and an online dialogue in order to learn how to develop an understanding and an interpretation that was broad enough to get an inclusive vision of health rights on the health indication. We then work with another colleague on the rape indication, and we produce documents and deliberations on those documents that were regional and inclusive. And on 2017, we were thinking on debating an indication in case of a diagnosis of a fetal malformation or disability. Actually, we have huge conversations. First of all, the first conclusion was not to write about it, not to specify it, not to and to move towards an idea that whatever was under that indication, we were not going to push forward about it. And if you look at the history of the drafting of the proposal of the National Campaign for Legal, Safe, and Free Abortion in Argentina, you will see that the drafting of that clause changed and ended disappearing. So the idea was that we didn't even need a special indication, and that whatever was happening in that conversation could feed the other indications, especially the health exception or the life exception. So, and that's just whatever is your position, and whatever is the position of different representatives of the people with disabilities movement and the feminist movement, we were having, of course, different views about it. It's just an example to show you how much this was about meeting, having conversations and deliberations, first in legal and social mobilization settings, and this was something that was also part of the 2018 debate in Argentina. If you look at the people who went to give their views, there were representatives of the different movements, including like the trans rights movement, and also the movement of people with disabilities. Also, if you were to trace some of the internal debates that took place among members of the House and their writing teams and their negotiating teams, among those who were in favor of the legalization bill, there were very important debates in which we invited experts and representatives of disability laws and the disability movement to give us their views. So this was part of the process, that we included the actors, and then we deliberated of different alternatives of how to translate agreements and compromises in the drafting of the law. And I think that both in terms of the social and legal mobilization, but also the political instance in Congress, this was a process in which we tried to have the conversation and to deal with the different views. And also, if you look at the bill that was passed in 2018 and the bill that was finally approved in 2020, the one that was not defeated in Senate, you will see a difference in the drafting that is part of the process of the conversation that continued in that sense. So this is what I mean by inclusive, participatory, and delivery, and very densely instantiated.
Very different than strategic litigation. I can tell you cases of strategic litigation in which even when you were asked to participate as an intervener, the lawyers disciplined you. We don't talk like that. We don't write about that. We don't talk about, we never use the word child. We use the scientific terms of fetus or embryo. And I remember at the time we said, like, that's not how people who experience it talk about it. And it was like, yeah, but in legal discourse, that's the language of the other side. And so you started to watch, in a way that popular debates, they changed that, and lawyer talk has a structure to it.
Yeah, I want to add something in that regard, is that this vision that I'm sharing with you requires a different type of lawyer, a lawyer that feels that it's his or her role is the service to the political leadership or the social movement leadership, not to run the show. Like, you are behind them, trying to interpret their views of how you can instantiate the agreement in the law of the visions that they are bringing you as political representatives of social actors. It's a very different type of perspective of what's your role as lawyer or legal scholar or advocate or advisor.
Okay, Avital.
Hi, yeah, thank you so much. It was a wonderful talk. I was wondering if you, at this discussion about the rhetoric and how the language has been used, especially with the human rights law, it reminded me of during COVID, the phrase "my body, my choice" very much became appropriated by the anti-vax movement. And I think it's possible now that phrase has a different meaning now than it did before COVID. And so I'm wondering if this appropriation of human rights law into the way it's being used in Brazil, for example, is that changing how that human rights law now can be used in other areas? Is it having sort of a backwards effect on the law?
Yeah, no, I think it was a great insight, and you're right on. I think there's nothing kind of peculiar about abortion. I think it's reflecting a much larger social moment in it. And you might know somebody who's really popularized it, Naomi Klein, in the book Doppelganger. She's doing this kind of look to more about the way in which critiques get appropriated as well. So I think you're absolutely right. And And the idea though behind it is that there's an intentionality to it. Do you know what I mean? It's either a political opportunity, but I think there's also a sense of a political attack too. There's a way in which you use the language not in a belief structure, but in a way of diminishing its value for political conflict. And so I think kind of watching the different ways that it works in the abortion context in particular, because there's such this double facing, because there's such a clear anti-abortion rhetoric at the same time as using liberal abortion law, I think the intention there is to really defeat this form of law. And so it does ask questions of feminist engagement with law, I think in real terms, yeah.
Okay. Paula, you're fine? Okay. Erika?
Hi, thank you for the talk. Actually, so when you were discussing post-colonial states, it kind of made me think about the example of India, where there have been several cases where the courts have tried to liberalize abortion rights, and the legislature has caught up. I don't want to say it's there yet, but it's getting there. And then I look at the context of the highly Eurocentric international legal sphere and the strong lobbying, anti-abortion lobbying in Western countries that do control a lot of the aid and funding that goes out of these international institutions. So in this context, I'm just wondering if you think that abortion rights advocacy in these countries like India should abandon international legal spheres altogether, given that it might have a more restrictive role in their country as compared to flourish along with that and try to make international law also flourish in abortion rights?
Paula, do you want to?
Yeah, I want to say that I haven't been doing abortion advocacy work more recently, because most of what feminists like me have done was to shift to the other big democratic debates and social debates that were pending, which were more economically oriented and about like material inclusion for women in Argentina. But I also remember that in all the meetings I was since 2016 for the Latin American conversations, we were already having the clear perception that the national constitutional conversations were much more important than the regional or the international ones already. So, and this, you can trace it back to the fact that feminists have been producing very important court decisions in Mexico, in Colombia, in Chile, in other places of the region, which are national decisions that used sometimes a little bit of international law, but they are mostly based on constitutional law debates that incorporate international human rights law as part of the local constitutionalization of the human rights framing that is more typical of the region. So from the advocacy perspective, it's been a while since Latin American feminists have thought that it was time to work with the more developed laws that we have at the national level than thinking about the international realm. And that's my experience as an advocate who was involved in this conversation some time ago. If we trace the work that is being done now, I think that some of the feminists are doing an important work in terms of getting to be appointed in the international institutions in order to protect them from the backlash. So it's also a shift from the idea that our work is producing arguments in terms of like the social mobilization or the legal mobilization in which we are actors in courts, to the movement in which we see ourselves as members of quasi-judicial or judicial or political bodies, which is like also part of this shift, is that protecting these conversations in terms of international law and international backlash is not only about keeping the participation in the arguments, but also participating in drafting part of the conversation. So this is another move that you can trace in Latin America. I don't know if this is happening in other places of the region, of the world, or of the global south, but this is something in which you could look at the experience from India to other places of the global south.
Thank you.
Claire Jones.
Yeah, I have maybe a bit of a variation on my question, and I think it goes a little bit to what was just said, but something I found interesting in your article, Joanna, was this idea that the discourse about global abortion rights sort of can draw this uncomfortable line between colonial domination and human rights globalization. And I'm kind of wondering if you could just speak a bit more about the implications of this Western moral bias, sometimes associated with international human rights law, and kind of how we can maybe address the concerns in countries like Sierra Leone, for example, that global abortion rights can be perceived as sort of an imperial threat against national culture.
Yeah, I mean, I think so in that piece, the sort of article was something to give you a little bit of background, which was to position that as a political conversation about abortion rights, that wasn't there otherwise because of a desire to speak about it either in terms of moral abstractions or public health evidence, right? And so that was one of the conversations which international law sort of didn't want to engage, and yet in some ways you can fast forward into the current climate in which indeed by leaving this vacuum in the politics of abortion, it was absolutely filled by an authoritarian politics. Yeah, so I think for the purposes of the conversation today, that article was there to say that there was this real anti-politics in international human rights law. And in that particular article, I looked at politics of coloniality, but you could look here at authoritarian politics or, yeah, indeed, but it was the idea of anti-politics can get filled with a politics. And so only to say like, yeah, that's what we saw in 2017 and really what's emerged in 2023. Yeah.
Yes, Verna.
Thank you for your presentation. You were focusing on how the abortion law evolved in the past centuries, and I was wondering if in the 21st century there is a threat to abortion law, not within itself, but from a broader perspective, considering data protection, and especially in terms of the US with the period tracking apps. Is that like a real threat to abortion laws, or would you think that was like an overreaction?
Pivot. Let's see. So I don't think digital tracking apps are a threat to abortion law, but they're definitely a threat to people who do help and support people to have abortions, most certainly. But maybe I'm trying to think of connection into the material today. I mean, one interesting thing in where period apps have come in is because as you've had more restrictive laws, and you might be talking about the context in the US, for example, right. Yeah, after the Dobbs decision. So here's an interesting turn, and it's the last part of the paper that we're working on, and maybe this is a nice link into the question that you asked, which is, there's another path that feminists have taken, and you might be talking about, and that kind of digital security is a really big part of direct abortion activism, where people are doing it regardless of the law. And that's been a sort of response here, which is a feminist skepticism of law altogether, and just a turn away from law, quite frankly. And in Poland, this was particularly what happened in response to the Constitutional Tribunal's decision. It led to these nationwide strike actions. And they were kind of originally designed as a protest against the judgment and the tribunal, but later they really became protests against the entire sort of state structure of law and quite frankly of the state's claim to the rule of law there. So I think abortion politics took a different case. I was particularly involved there in a case of an abortion rights activist, Justina, who was charged on aiding and abetting charges related, and of course digital apps, this is about surveillance and the Polish state surveilling in significant ways, but usually I have to tell you it's not actually the state, who it's most likely surveilling you and is your greatest threat. And that's why period trafficking acts are not actually your biggest threat. It's the person sitting beside you who's looking at your messages openly. It's most often family members, friends, who end up being the people who are the reporting agents. And so in this case, it was, of course, an abusive husband who reported on their wife having received these pills. But the reason the case is so interesting is because she was charged with aiding and abetting. But she defended her actions by saying, like, it's impossible. It's impossible that helping and supporting your friend is a crime. It's impossible that compassion is a crime. It's impossible that caring is a crime. Now, the court disagreed and they convicted her under the abortion law, but it's pretty incredible what the public response was. The largest national newspaper in Poland gave her the award for Women of the Year. Yeah, like it's absolutely the public kind of turned. And the idea is, if your law is not enforceable, then is it a law anymore? And I think there was this real turn, especially of this more radical branch of the abortion rights movement, to just turn away from law as a core component of abortion rights. They turned away from liberal law, I think in a bunch of disagreement with the idea that the compromise is anything they should compromise to. But the other thing I think they really turned away from is just the idea that, like, abortion rights come from law. They really just refuse that idea, because if you refuse it, that they come from law, then neither can law take it away from you. And quite frankly, this was a really fascinating debate that happened in Canada as well. I don't know if anybody remembers this. After the moment of the overturning of Roe v. Wade and the Dobbs decision, here, Prime Minister Trudeau offered a law to feminists. Yeah, it said, would you like an abortion law to protect your abortion rights? And overwhelmingly, the feminists said, no, thank you. Yeah, they said no to an abortion law. And it's really fascinating to think about what that no was about. You know, why actually people find a state of unlaw to be more protective of rights than in this case, a particular offer from the Liberal government to protect abortion rights.
I can maybe add a question in that context also around the inherently political nature of some of the human rights debates. I mean, you rightly point out the issue of proportionality and how compromises that are imposed by the court can then change depending on the political shifts. But in many debates around human rights, you do have tensions, and you do have proportionality analysis, and you do have restrictions of some individual rights for, say, the promotion of structural equality. I mean, I'm not talking about the abortion right, but I'm fascinated by how does that apply to other debates, certainly in the context of labor rights, rights related to persons with disabilities, where group concerns about structural oppression are put forward by disability advocates, and individuals disagree. So there you'll have proportionality analysis, but obviously that's the danger of these things. They can change, so yes, depending on the constitution of the court, the composition of the courts. So in other words, what I'm trying to get at is, it's in and of itself probably part of the debate around how you fill out what the liberal state should be doing in some contested contexts. So I'm thinking outside of the debate of abortion, but what I'm interested in is, are you saying, well, we should get rid of the proportionality idea in and of itself, or is it more, well, it's pointing out the problem that yes, these things shift, and that may kind of threaten acquired rights, but it's part of the difficulty of dealing with human rights and proportionality analysis.
Yeah. I mean, Paula, I don't know if you want to I have an immediate response, that I think about. I mean, it's kind of fascinating to hang with activists because in some way they just don't talk in terms of proportionality. That's not their language. And in particular here, and it's not that they're not concerned with the same values that you're concerned with, but they'll answer them through ideas of solidarity, of mutual aid, of leaving nobody behind. Like, they have other ways of talking and thinking about those values than liberal doctrines of proportionality and balance and so forth. So So it has been fascinating. There's this whole body of work and in abortion rights, and it's specifically spoken of beyond law. And I think this idea of beyond law, people initially take it as though it's civil disobedience or, you know, it's illegal is the speak, but it's not. The way activists talk about it is illegal. It's being able to socially organize yourself outside of the dictates of law and liberal thinking.
And it's the lawyers who put it then in that framework.
Exactly. And so it's actually fascinating to watch the relationship between activists and their lawyers sometimes, because there's this frustration of being able to speak in these ways of organizing themselves that are cognizable to abortion law lawyers. And so they end up actually getting lawyers from outside the abortion law movement to be able to articulate it in a different way. And they're usually, you know, there's an anarchist instinct to the way of them working that is something in tension with traditions of abortion law, liberalism. So yeah, I think it's a kind of fascinating space. And again, it's a flank of the movement. And as Paula says, there's another flank of democratic law movement, and you're seeing these real futures coming out of, the same conflict.
Okay. Yes,
I wanted to add that I wanted to remind us that there was a time in which we didn't assume proportionality was the only game in town. We compare the view, like the balancing approach of the US court in the past and the US legal tradition to the proportionality analysis of the Germans and other Europeans. And there is some perspective, I think, in the legal academy, in the legal scholarship, in the professionalization of lawyers that tends to drive us to the idea that the conversation on proportionality or the adoption of the proportionality test is also like the only way to professionalize our conversations. And I just wanted to highlight in which sense we lead for most of the history of the liberal paradigm with the balancing approach, and how this was maybe a way of dealing with the conversation that was more democratic in terms of the wider access that it provided to people that were understanding that this was a way of dealing with the legal and the moral dimensions of the conversation. I think that the push toward the proportionality analysis and the expansion of the idea that proportionality is the way to face conflicts of rights or of values or values and rights, etc., as the main and only paradigm, makes us forget for how long we were having reasonably liberal conversations or political conversations in terms of balancing. And in a way, this is something, if you were to trace the level of the conversation in the deliberative process that I described about Argentina, Mercedes Cavallo, a graduate of Toronto and a student of the proportionality analysis, was one of the very few persons who took that dimension of the conversation to the national debate. Of course, for professionals like us, she did a very, very elegant work. But in terms of the wider conversation, this was a type of talk that is for very specialized professionals. Even within the legal community of Argentina, very few people are able to follow the proportionality analysis as we as scholars or in the constitutional law professional world are able to do it. So I just wanted to remind us that there was a time in which we were perfectly accepting balancing conversations in a much rough way than the proportionality method suggests.
Okay, so I have Rebecca and Vivian put her hand in the back. So both of you, maybe if you can formulate your question, and then we'll have to wrap up already.
Congratulations on this project. It's a very, very exciting perspective on the developments of feminist futures. And I want to focus on feminist futures and ask, you've chosen Argentina for very good reasons. Why have you chosen Chile and Ireland and not other countries like Colombia, Mexico, South Africa? Maybe it's a much bigger question that can be answered in the time frame, but I just put it out.
So I'll let Vivian formulate her question, and then you can decide what, okay?
Okay,
Thank you for speaking. Just in terms of talking about, turning away from law and how abortion is sometimes outside the legal system in some regard, at least. I was wondering how you thought international guidelines, like whose abortion guidelines for interest, kind of played a role in that interaction, globally as well as in Canada.
Okay, so please provide a short answer, and I know there are many more students who send questions. I actually forwarded them to Professor Erdman. You may provide an answer afterwards, or students can come up and talk to you. Okay.
So Anna, if you want, I can try to answer Rebecca's, and you can answer the second one or complement my answer. Thank you, Rebecca, for your question. I think that there are different ways of answering. First of all, this is a commissioned article in which, with Joanna, we agreed that we are not going to do an exhaustive empirical research. It was just going to describe patterns of change and make an argument. And it's disputable, and we hope to follow up the conversation and also produce more evidence, more systematic evidence. And we want to invite others to engage in more systematic evidence and so different selection reasons for the case studies. This is just a very broad answer on how we framed the project in terms of testing if we could make this argument with the evidence we have as insiders and as Joanna started the talk, as having lived through the last 20 years of these changes and challenges, and also the work behind the reforms, etc. Also, I think that once this approach was our decision, it was obvious that we wanted to trace democracy in the obvious places in terms of the wider nationwide conversation, etc. And at least as far as I know, the Mexican case and the Colombian case are more typical cases of the liberal era that Joanna introduced, because they are more focused in the courts. Even if from the courts, those countries were able to start kind of nationwide conversation or wider conversations that exceed the legal and judicial settings. I wouldn't say that they are as large, as an inclusive and as diverse as the conversations we can describe with the Ireland and the Argentinian case. And the Chilean case is a kind of a negative case in terms of variation within the democratization and the democratic abortion law setting. It's not that it's the success story, but it has very important key deliberative traits that we want, and democratic traits that we wanted to highlight as part of this pattern. That's my take. I don't know, Joanna, if you want to supplement or also contradict it, because it's not part of what we have discussed in very detail.
Yeah, and there we were kind of doing institutional comparison. So Ireland, significantly, abortion law by referendum. And the activists moved in a different kind of way. This was about a constitutional question in the making of the state. It was going to change the fundamental nature of what was the Irish state. And so it was a much larger question than the abortion law. And they ran it that way as well in the campaign. And Chile was the same thing. It was in the remaking of a constitution. And where were abortion rights going to be in that remaking of this constitution for a democratic Chile? Because the constitution, of course, was the constitution from Pinochet regime. So the abortion questions became of so much larger, and of the reordering of the democratic state. So that's why we chose those two examples. And we wanted to draw especially the contrast to even the more expert-driven commission work. Even if it's not courts, for example, in Australia, they were expert commissions that were doing that kind of work. And they, again, didn't have the same kind of democratic character as referendums, as constitutional assemblies or conventions. Yeah, that's why we chose those examples.
I will keep it at that. Maybe you can address Vivian after the class, because we have to enter the room.
Okay. Thanks.